Mr. Mark Horowitz, can you hear us fine?
I can now, sir. Yes.
All right, and Miss Kim Swackhammer, can you hear us fine?
I can.
Okay, and they're both appearing by Zoom from a remote location. And counsel for defendant appellee, defendants appellees, you want to place your appearance on the record?
Yes, Your Honor. Matt Boyda for the defendants appellees in this case.
All right, and as I mentioned, this is an appeal from the denial of a variance from the Zoning Board of Appeals. I have reviewed the papers filed by the parties, and the briefs in support of and in opposition to the appeal. Mr. Horowitz, any argument that you want to make as to the appeal? Go ahead.
Thank you, Your Honor. May it please the court. My name is Mark Horowitz, and with my co-appellant, Kimberly Swackhammer, my sister, we appear before you today to argue that the Zoning Board of Appeals decision regarding our property at 178 Riverside Drive must be reversed. We're not here to re-argue the facts, but to review the ZBA decision against the four statutory pillars of judicial review defined by MCL 125-3601. The record demonstrates the ZBA failed on every count. The resulting decision is an error of law based on improper procedure and is unsupported by evidence. The underlying cease and desist order is void ab initio. Pillar 1. The decision fails to comply with the Constitution and state law, particularly MCL 125-3606-1A, which is this pillar. The ZBA's decision is illegal because the board willfully refused to exercise its mandatory statutory duty under MCL 125-36031. MCL 125-36031 mandates the ZBA shall hear and decide appeals from and review any administrative order. The ZBA minutes confirm that the questions regarding the C&D's legality and our vested non-conforming use status had clearly arisen. The ZBA actively chose not to decide them, thereby neglecting its core legal function. I will point out two items for you. The first is directly from the transmitted meeting minutes on page 3. Horowitz, and I quote, Horowitz then asked the board to clarify for the record whether they would be ruling on all elements of his request, including notice correction, non-conforming use status, and the cease and desist order. Bedwin asked whether the Planning Commission had previously discussed the property's non-conforming status. O'Brien and Hornbeth confirmed that it had. Bedwin also brought up the different checkboxes on the application, but Sobalski clarified that the board must address only what was officially submitted, the use variance. The board briefly discussed granting non-conforming use, but concluded it was not an option by law. The second statement is from Exhibit ZZZ 42, which is the meeting transcript generated by Otter AI and authenticated by me via an affidavit found in Exhibit ZZZ 87. Adam Bedwin makes a motion to deny correcting the notice and says the following at the 43-minute and 28-minute mark. I make a motion to deny the request to reissue a notice. Here's why. The notice requirement just needs to state the nature of the request, not the specifics of whether you're seeking nonconformity or a use variance. Everyone in the public here today knows why we're here. It's because you want to be able to use it as a VHR. So I think the notice is entirely adequate. We know why we're here today. Furthermore, in that same exhibit, at the 1 hour, 37-minute, and 44-second mark, Adam Bedwin also says, at this time, without any written notification of the city's stance on non-conforming status, I don't think we can rule on it because there's nothing to appeal. So essentially, they are ignoring all of the issues that we raised. Second, the fundamental illegality of the C&D itself. The ZBA implicitly validated an administrative order that was illegal ab initio. We established this for 4 reasons. and the CND violates state law and due process. First, it was issued in silence of our vested nonconforming use property rights, a vested right that the city never investigated or addressed. Exhibit MM establishes the entirety of the investigation that occurred prior to the issuance of the cease and desist, and it is void of any investigation regarding nonconforming use. Number two, the city admitted it skipped the mandatory due process hearing required by Chapter 120. 120.08 claims, which is in 120.08, claiming that it had already determined our illegality, the very issue the hearing was meant to resolve. This is a clear due process violation. 120.08 says the property owner shall be invited to respond to the complaint and present evidence and respond to evidence produced by the investigation within 10 days from the date of the notice. That hearing never occurred. Number three, the ordinance implicitly cited in the CND was a non-operational and unenforceable ordinance when issued because the city had failed to enact the mandatory licensing fee for over 15 years. 120.06 says the annual license fee shall be established by resolution of the city council. Licensing is the core of this ordinance, so much so that the very definition of a vacation home rental includes licensing as a critical component. The definition says vacation home rental is the use of a dwelling where the dwelling is rented or sold for any term less than 30 days and licensed pursuant to city ordinance. Without licensing and without the infrastructure for licensing, this definition cannot be met, and the ordinance is void for vagueness and the impossibility of compliance, and is unenforceable. Lastly, the CND itself was procedurally defective, failing to define the ordinance violated explicitly or to provide the necessary appeal instructions. You can see this in Exhibit G, which is the CND itself. Pillar number two. Was the decision based on proper procedure? The ZBA's hearing was procedurally invalid, resulting in denial of due process. First, there was ex parte communication. The record includes a memo from the zoning administrator, the very official who's issued the challenge cease and desist order, that provides a legal evaluation and a recommendation of denial. This is an improper ex parte communication that corrupted the impartiality of the board. Secondly, they improperly restricted the jurisdiction. The zoning administrator, as we read earlier, unlawfully directed the board to restrict its review to only the fallback use variance based on a checkbox on a form, thereby ignoring the primary appeal of the VNC use status that the ZBA heard but did not decide. Lastly, there was defective public notice. The ZBA refused repeatedly to correct the public notice, despite being advised multiple times that it failed to accurately state the nature of the appeal. This violated MCL 125-3604 and 125-3608. Pillar number three. Was the decision supported by substantial evidence? The ZBA's decision is not supported by legally competent material and substantial evidence. The evidence is a failure on abandonment. The city's legal theory of abandonment ignores Michigan law. Under Heath Township versus Saul, abandonment requires not just a cessation of use, but affirmative intent to abandon. The ZBA record is void of any evidence of this intent. Second, judicial admission. The city's own counsel, Mr. Voida, made a judicial admission that the question of intent to abandon was still unresolved and was what discovery is for. The ZBA's decision therefore rests on a record that is legally deficient and cannot satisfy the standard of review. Number four, the decision does not present a reasonable exercise of discretion. Given the wholesale disregard for the law and procedure, the ZBA's decision constitutes a clear abuse of discretion. Discretion is not a license to ignore the law or process. It is an abuse of to ignore mandatory legal duties. It is an abuse of discretion to render a decision that is unsupported by substantial evidence and contrary to settled Michigan property law. Lastly, broader impact. Finally, Your Honor, the court must consider the dangerous precedent set by affirming this decision. To affirm this decision would effectively rewrite state law in 7 critical ways. First, it would rewrite MCL 125-36031 to state that the ZBA may hear and decide questions that arise, rather than its current mandate that the ZBA shall hear and decide. It would sanction, secondly, it would sanction a zoning official bypassing a mandatory due process hearing, such as Chapter 120, Section 12008, by deciding the matter unilaterally and preempting the required process. Third, it would rewrite MCL 125-3608 and the Open Meetings Act to state that specific notice is not required for zoning hearings, thereby sacrificing public participation and fundamental fairness, which is required by due process. 4, it would rewrite Michigan case law, such as Heath Township versus Saul, by eliminating the requirement of affirmative intent for abandonment, thereby establishing the dangerous precedent that a vested nonconforming use, a constitutionally protected property right, can be extinguished through implied abandonment and without clear judicial finding. 5, it would sanction improper ex parte communication, allowing the administrative official whose order is being challenged to influence the ZBA's quasi-judicial decision-making process. 6, it would establish that the city's failure to fulfill its statutory duty to make an ordinance operational by ignoring the licensing fee requirement for 15 years does not affect its power to enforce that same non-operational ordinance. Lastly, it would establish that the ZBA can validate the legality of a cease and desist order without requiring the city to rebut claims of its illegality, thereby placing no burden of proof on the administrative body. The court's duty is to ensure the administrative process adheres to state law and constitutional due process. The ZBA failed to do so repeatedly. In conclusion, Your Honor, we asked for the following relief. We ask that you reverse the June 18, 2025 ZBA decision, declare the cease and desist order void ab initio, hold that 178 Riverside Drive retains its vested nonconforming use status as a vacation home, rental, and a 2-family dwelling, and you decline to remand it as it would be futile and unlawful to grant the city a second bite of the apple to cure its own evidentiary failure. We thank you, and we are able to answer any questions you may have.
All right, Mr. Horowitz, I do have a couple for you. One, as I understand the city's argument, they're saying that what you applied for to the ZBA was a variance. And then when you look at the standards for granting a variance, this case doesn't fit into those standards. What you are asserting is that you have a prior non-conforming use under both the Zoning Enabling Act and under the Sheboygan zoning ordinance. So why is it that your appeal from the denial of a variance should be the mechanism to address this non-conforming use issue?
Well, sir, we didn't just apply for a variance. The zoning administrator is attempting to limit the scope of the ordinance, which is not even his jurisdiction, the scope of the appeal, to a checkbox on a form. If you look at the handout that I submitted to the court, I'll make it pretty simple for you. On March 21st, we submitted a ZBA appeal, and we talked about the existing non-conforming use. On April 30th, if you look at the entire packet that we issued, we repeatedly talk about the use variance in accordance with a non-conforming use. We explicitly rate non-conforming use. We talked about the non-conforming structure in the packet as well. On in the ZZZ exhibits, ZZ 1 through 8, on May 31st, when we initially saw the public notice that was sent to the that was provided, we notified the zoning administrator and the ZBA that the notice was incorrect. We were not seeking just a use variance. That was a fallback request. We repeated that on May 7th, May 12th, May 14th. I'm sorry, June 7th, June 12th, June 14th, June 16th. And in the hearing itself, the meeting minutes explicitly state that we raised the issue. The statute 125-3603 says the ZBA shall hear and decide all claims arisen. It doesn't say that if you don't check a box on a form that says check one only, that limits your scope. And that's what they're attempting to do, is say that it limited our scope so that they can narrowly decide something that required the most difficult hardship requirements. That is not what we submitted, nor is it what they heard.
So the on that appeal form, when it says action requested, check one, and you checked the box to grant a variance to certain requirements of the zoning ordinance, there would have been other ones that might have fit more properly, like to interpret a particular section of the ordinance as it's felt that the zoning administrator is not using the proper interpretation, say as to the non-conforming use, or to overturn the action of the zoning administrator, I guess to challenge the issuance of a cease and desist order. So that maybe those might have, none of them really seemed to be a perfect fit to what you were asking for. So you were trying to fit it into one, trying to fit a square peg into a round hole, and you picked the one that you thought worked. And in the substance of your application, you discussed the non-conforming use status. So do I understand your position rightly there, that that's why the ZBA should have ruled on your non-conforming use status?
That's correct. That's the reason why they should not have limited the notice.
Okay.
However, even limiting the notice and then hearing it, they heard all the things we had to say. We raised it multiple times.
So then my question would be as to remedy. You said that a remand wouldn't be proper, but why wouldn't that? If I agreed with you if I agreed with you that the ZBA had some obligation triggered by your appeal form to decide whether you had a valid non-conforming use, then wouldn't the proper remedy be to send it back to them to make that determination?
Well, a remand in this case won't correct several fundamental problems. Number one, the remand would have to be reviewing the same exact record. So two things: the C&D itself is void ab initio because of the issues that I raised earlier. No amount of remand or there's nothing on the record that would change the fact that on June 10th of 2025, the city council established fees for the very first time. Nothing is going to change that. Number two, nothing will change the fact that 12008 was not met. They did not have a hearing. Okay, so the C&D is void ab initio, and that's a matter of law. Number two, nothing on the record in the ZBA would allow you to claim that there was abandonment of the VNCU. Abandonment requires a two-pronged test, both the cessation of use and the affirmative intent demonstrated by an overt act. There is nothing on the record. They don't even try to say that intent was established. So there's no reason to send it back.
All right, thank you. Now, Ms. Swackhammer, you're a plaintiff on this appeal representing yourself as well. Do you have anything you wish to add in terms of any arguments?
No, he covered it. Thanks.
Okay, thank you. Mr. Voida, city's response.
Good morning, Your Honor. And I believe you have essentially grasped the basics of our position. As you know,
so you're saying that this was an appeal for a variance, and the legal standards for variance aren't present here. I agree wholly.
yes,
That if the question presented today is were there grounds for a variance to be issued? The answer to that is clearly no.
Okay.
So you've laid that out in quite a lot of detail, and I don't even know that the plaintiffs dispute that. Although they seem to confuse variance with the non-conforming use. But my question to you is really what I asked Mr. Horowitz and Ms. Swackhammer. Well, I guess I have a different question for you. If the appeal form had been submitted saying, hey, we got a cease and desist order to stop doing something that we think we're allowed to do as a prior non-conforming use, does the ZBA have jurisdiction to hear that?
I think if it's viewed as a request to overturn the action of a zoning administrator, so to the extent the cease and desist was a zoning administrator action that was an enforcement action, I think that would be appropriate grounds for ZBA consideration. I don't think they made that request. I think that's something that they have engrafted onto this appeal subsequent to the request that they made of the ZBA, and the ZBA said, look, we're here to consider a use variance request. We're not here to consider anything else. But I do think that would be appropriate for the ZBA to consider if it were presented.
So when I look at, and I know there's a companion civil case where they're saying that it's a denial of due process and other claims for the city to try to deny them the non-conforming use. So there's some overlap here, but the Zoning Enabling Act does allow for prior non-conforming uses to continue, although the use doesn't conform to the zoning ordinance or amendment. And then Article 13 of the city's zoning ordinance has several detailed provisions about the parameters of how they will how they'll treat non-conforming lots, uses, and structures.
Yeah.
What I didn't see in Article 13 is any description of any process. So like let's say that I'm in the city of Sheboygan and I have property that does consist of a valid non-conforming lot, use, or structure. What am I supposed to do about that? I can either continue and assert the non-conforming use as a defense to any enforcement action, right? That's one option.
Right.
Or I can file a lawsuit for a declaratory judgment that I have a non-conforming use,
Yes.
which seems to be what the Swackhammer and Horowitz have done. Is another path available to me to go to the ZBA and say I want some declaration that this is a non-conforming use? Is that a proper path?
Well, not so, when you look at the powers that the ZBA has, one of them is to interpret the ordinance. And I suppose to the extent that the ordinance defines what a non-conforming use is, that could fall into an interpretation situation.
But how to apply the ordinance to a contested set of facts isn't really interpreting the ordinance.
Correct. I think it is a bit of a square peg round hole situation.
So if there's a contested set of facts about whether a lot, structure, or use is non-conforming, is a valid non-conforming, prior non-conforming use, I don't know what the right term is.
Yeah.
If there's a contested set of facts about it, who sorts that out? Does the circuit court, either in a defense to an enforcement action or a deck action, or is this ever something the ZBA can do?
So I certainly think that a deck action is an appropriate venue for that sort of thing.
And we have one pending.
Right. We're fighting that battle in this courtroom on a different day at a different time. I think under certain circumstances where the zoning administrator has taken some enforcement action, the ZBA is empowered to address the actions taken by the zoning administrator. And so I think in that situation, not in every situation, but I think in situations where there is a lawful non-conforming, prior non-conforming use, and there's some enforcement action taken by the zoning administrator, the ZBA would have the power to address whether the zoning administrator's actions were legitimate.
So it's just to assess the enforcement action.
Yes.
So the
But-
cease and desist letter, was that issued by the zoning administrator?
It was not issued directly by the zoning.
That's a zoning compliance officer, right?
Correct.
Okay. So we don't have, does the city have a zoning administrator?
It's the city manager.
It's the city
He
manager.
wears 2 hats, well, multiple hats, but that.
So where it's not the zoning administrator or the planning commission taking some official action, it's the city's code enforcement officer saying, hey, I'm telling you, if you don't stop this, I'm gonna write you a citation. Or we could bring you to court. Is that action something that the ZBA has jurisdiction to evaluate? Or does that trigger a property owner to say, gee, I better go file a declaratory action?
Well, I think there are 2 clear options there. One of them is to file a deck action. The other is if there is some sort of enforcement action filed in the courts, it may provide a valid defense to that action.
But the cease and desist letter itself, what legal effect does that have? And is it an action that the ZBA has jurisdiction to review?
I think in this case, I don't see where the ZBA would have the authority to do that because it's not an action taken by the zoning administrator. I do think that unless it was determined that the compliance officer was acting sort of under the umbrella of the zoning administrator in zoning enforcement, zoning administration.
Yeah, but what
Which is
about,
an interesting
how does that fit under the statute cited by the plaintiffs, that section 3603(1) that says the zoning board of appeals shall hear and decide questions that arise in the administration of the zoning ordinance. And then it talks about some other things. And then it says, it shall hear and decide appeals from and review any administrative order, which just wasn't, requirement, which just wasn't, decision, probably wasn't, or determination made by an administrative official or body charged with enforcement of a zoning ordinance adopted under this act.
I think at that point, it does fall under determination or something along those lines.
So a letter from somebody in their official function to enforce the act, enforce the ordinance, sends you a official letter saying cease and desist from this use. And you receive that letter and you think that that's an improper cease and desist order or letter because you have a valid prior non-conforming use. May you file an appeal to the ZBA to have the ZBA say, yeah, they shouldn't have filed that cease and desist letter. Let's let you sort it out in the courts. Or they shouldn't do it because it's clearly a prior non-conforming use. Or maybe they say, based on the record we have, you abandoned that non-conforming use and we totally support the cease and desist order. And now we're reported a different way. Do they have jurisdiction to do that?
Based on the statute, it sounds as though they may. I mean, I'm just getting hit with this today, so I'm kind of flying by the seat of my pants here, but
if they do, is your position still that they didn't have to in this case because this appeal checked the box asking to grant a variance?
well, it didn't just check a box. I mean, there were words included after that box that were written by and signed by Mr. Horowitz. We are seeking a variance from the restrictions as an R1 to allow for the occupation of 2 dwelling units that exist. We seek the granting of a usage variance in accordance with the non-conforming usage of this structure for at least a decade and likely far longer. They're defining this as we want a use variance. And the interesting part about that second comment is if it's a lawful non-conforming use, you don't need a variance.
Right.
So it's kind of conflicting language there, but they've said we want a use variance. They didn't say, well, we want to challenge a cease and desist letter that we received, or even we want you to interpret the ordinance as it relates to non-conforming uses or something along those lines. What they said is we want a use ordinance, and the ZBA said, well, we're not going to give you one because we don't think it's appropriate.
So what would happen if I affirm the denial of the variance? Could the plaintiffs tomorrow file another appeal to the ZBA and say, hey, we have this cease and desist letter that we think is invalid. We'd like you to review it. Could they do that? Is there some time limit to that?
There is a time component to that. I don't want to commit to that. From a subject matter standpoint, they could. I don't want to speak as to the time component. but from a subject matter standpoint, they could. It's not unlike, it seems to me the last time we were in court, I think it was on a different issue, it was on the other case, where Mr. Horowitz brought in some new material and he said, hey, I'm not saying that we can't hear this, but we can't hear it today. I think that's where we are with this. It's a situation where he could potentially bring a different claim in front
I
of.
mean, would you agree from the substance of the appeal to the ZBA, even though the box was checked to grant a variance, and even though the plaintiffs frequently said, we want a use variance, they said, we want a use variance, meaning we want to vary from the use required by the ordinance because we have a prior valid non-conforming use. So substantively, the only basis that they were asserting, they didn't even assert the required grounds for a variance, right? They asserted a non-conforming use as the reason to grant the variance. Is that true?
Certainly as one of their reasons, yeah. I mean,
Yeah, I know they have some side things about the
Right.
process and the ordinance itself.
And yeah, so certainly that's one of their reasons, and legally speaking, it's probably their strongest reason.
So why would it be inappropriate for me to vacate the decision and remand for a hearing on well, I guess it wouldn't be vacating the variance denial. The variance denial was appropriate.
And that's why I think you're answering your own question, Judge, because they asked for a variance and you've determined that that variance denial was appropriate. So what are we remanding for at this point?
So if they decide to file another appeal, then about the cease and desist, then we'll deal with that, whether it was timely or whether it was improperly granted or denied. We also have the pending civil action. If
Yes,
they prevail in that civil action, they're going to be able to continue their use.
right.
If the city actually takes an enforcement action against them, they can assert the non-conforming use as a defense. The denial of the variance isn't any kind of res judicata on that question because that wasn't decided by the ZBA.
Correct.
Is that all true?
Yeah, all the ZBA decided was whether or not a use variance was appropriate under Michigan law and under the provisions of the city's ordinance. That's the decision they made. So I agree with what you said.
All right. Anything else I need to know to understand the city and the ZBA's position?
No, Your Honor.
Okay. Mr. Horowitz, any rebuttal argument to those points?
Yes, sir. As you mentioned, 3603 doesn't, it states as you are reading, it shall decide appeals from and review any administrative order, requirement, decision.
You don't have to read to me something I just read.
Okay, great. You read that, but I also want to point out to you, chapter 154, you mentioned that 13, section 13, but there's section 14, which defines the ZBA's authorities and duties. And it says in there, appeals of administrative decisions. That's number 1. In this particular case, the council is not correct. In order for the ZB or the C&D to be written at all, they had to make a decision that our VNCU status was abandoned or extinguished. That is a decision that they had to make in order to even write the C&D, because they're stating that we're an R1 zone. So in order for them to even write the C&D at all, a decision had to be made. And that's what happened in this particular case. They're saying the decision was you were in an R1 zone because we had a vested nonconforming use that the council himself said in the previous hearing that we had a vested nonconforming use, that discovery was necessary to affirm intent or to establish intent.
Okay. Would you agree, Mr. Horowitz, if your appeal is treated or if your appeal to the ZBA is treated as whether you should be granted a variance under the standards governing variances, that you didn't meet those standards? Do you concede that?
Yes, I would concede that. What I would not concede, Your Honor, is that we did not raise to the ZBA multiple times the questions. So if you are to restrict it solely on a checkbox or the limitation of their subjective opinion, that's an unfair situation, given that we told them on May 31st, 19 days before the hearing, that their interpretation was incorrect. And we told them that we were seeking the affirmation of our non-conforming use, that we needed the C and D to be void because of that the use variance was a fallback. We explicitly stated that in multiple emails that are documented, that are on the record. The ZBA admitted all of our emails and our exhibits on the record. So the record is complete.
Okay, thank you. Ms. Swackhammer, do you have any rebuttal argument you wish to make? All
Nope.
right, thank you. This is an administrative appeal from the action of the City of Sheboygan Zoning Board of Appeals that had denied the request for a variance submitted by the plaintiffs. As is clear from the record and the briefs, the arguments of both sides, the grounds for granting a variance were not present here. The plaintiffs argue that this was really an appeal about whether a cease and desist letter was properly issued, and whether whether it was improper given the property's prior non-conforming usage. Although the non-conforming usage was mentioned in the appeal to the ZBA, the appeal form itself didn't even refer to the cease and desist letter, or say we're appealing from this cease and desist letter. So, I mean, I think on the one hand, you know, Mr. Horowitz and Ms. Swackhammer are trying to check a box that they think fits the situation best. And, you know, and maybe this is, you know, I hesitate to elevate form over substance when they mention non-conforming status in their appeal, but they don't mention the cease and desist letter. It's clearly asking for a variance. I think under those circumstances, I can't say that it was an abuse of discretion or improper process or illegal or unlawful in any way for the ZBA to deny a variance. So therefore, the action of the ZBA denying the variance is affirmed, and the appellees can submit an order to that effect. I want to make clear, though, that this has no bearing on the pending civil action that these plaintiffs have filed, asking this court to declare that they have a valid non-conforming use under the ordinance. They may well prevail in that action. I have no idea. I mean, I've denied some summary disposition motions, but in the full litigation of that case, I don't know. They may well prevail, and if they prevail, they'll be able to continue this use. It also does not prevent them from asserting the prior non-conforming use as a defense to any enforcement action that the city may take. If they decide on their own that they're going to continue this use, it doesn't matter what the city thinks about it. It's lawful use and they're going to continue it. If the city cites them, they can assert the non-conforming use as a defense to that enforcement action. It also, in my mind, doesn't prevent them from going and filing a proper appeal from the cease and desist letter to the ZBA. I'm not today determining whether they would be time barred from doing that. But I think that I agree with the plaintiffs that that cease and desist letter would be the type of administrative official determination that section 125-3603-1 allows the zoning board of appeals to hear. So my ruling today is fairly narrow, simply that the ZBA was reasonable for them to interpret the appeal as a request for a variance. The grounds for granting a variance were not present, and so they properly denied that appeal. So Mr. Horowitz, Ms. Swackhammer, if you want to pursue a different appeal to the ZBA, go ahead. You have the pending lawsuit in front of me, which if you win, that'll resolve these questions for you. Or if you want to just continue the use and assert this as I'm not advising you to do so, but certainly if you did that, then you would have a defense that you could assert to any enforcement action. But the way that this is postured is as a request for variance, and it was properly denied. So the appeal is denied, the decision's affirmed.
We'll submit that over, Your Honor.
Okay, thank you very much.
Thank you.
Have a good day.
You too.
Thank you.